May it please the court. My name is Hidalgo-Velez, and along with my co-counsel Jorge Izquierdo, we represent the appellants in this appeal. We would like to reserve 3 minutes for a rebuttal, if it pleases the court. Thank you. Since the filing of the briefs in this appeal, the Supreme Court of the United States issued the decision of Shadbourne versus Troyes, 134 Supreme Court Reporter 1058, which affirmed the decision of Roland versus Green, citing our brief as applicable to this appeal. Troyes is dispositive of this appeal, Your Honors, and its correct application should lead this court to find that it does not have jurisdiction over this case, this class action, and the proper course of action is to remand this case to the courts of Puerto Rico. In our brief, we asked this court to adopt the reasoning in Roland versus Green in answering the following question: whether the Securities Litigation Uniform Standards Act, or SLUSA for short, precludes, as a preclusion statute, a Puerto Rico law class action brought by Puerto Rico resident shareholders of a Puerto Rico registered investment company whose shares of common stock are not traded in any national exchange, by reason of the fact that such investment company, local investment company, may happen to hold its investment portfolio some nationally traded securities or covered securities, as they are called under SLUSA. Under Troyes, the answer is that such class action is not precluded under SLUSA. As we all know, SLUSA prohibits the bringing of covered securities class actions based on violation of state law, where plaintiffs allege misrepresentation or omission of the material fact in connection with the sale or the purchase or sale of a covered security. And again, covered securities are nationally traded securities or securities issued by mutual funds or investment companies registered under the 1940 Act.
But isn't your problem the in connection language, and that the in connection language allows the court to look beyond the form of the fund that you set up and to look to the actual holdings that the fund holds, which you concede rightly so include covered securities? Exactly,
Your Honor. Troyes, the dispositive language in Troyes, and I quote from page 1066 by voice of Justice Breyer, is that a fraudulent misrepresentation under SLUSA, a fraudulent misrepresentation or omission is not made in connection with such a purchase or sale of a covered security unless it is material to a decision by one or more individuals of the class other than the fraudster, in this case the fund, to buy or sell a covered security.
The problem, however, is that you've taken that narrow sentence. I don't blame you. It's a sentence that helps you. But there's other language in Justice Breyer's opinion that points the other way. And this same debate was played out a couple of months ago before the Second Circuit after Troyes on a petition for rehearing in Re Herald. And the Second Circuit didn't buy the argument that you're now making, and they said, in effect, that as long as there's a close enough nexus between the alleged fraud and the publicly traded shares, that's what's dispositive. Here, you've got allegations in your complaint which indicate quite clearly that the fraud of which you're complaining is in connection with the way in which investments were carried out or not carried out. That's precisely the situation the Second Circuit had post-Troyes in the Herald case.
That is incorrect, Your Honor. The allegations in our case are that this fund, in the investment objectives and fundamental policies, they announced in the prospectus that they would invest at least 75% of the total assets of this stock in debt securities issued by a bank in Spain regarding European markets, corporate bond indices that are not themselves covered securities. The language in Troy says, unless it is material to the decision, these fund shareholders invested in this mutual fund in Puerto Rico, not because they wanted to buy shares of Banco Popular, preferred shares of Banco Popular. Everyone knows in Puerto Rico what Banco Popular is. They could buy those shares themselves. What made this fund different is that these investors would be exposed to the global corporate bond markets via a debt instrument issued by a bank in Spain, Banco Bilbao Vizcaya Argentaria. That's what made it different. These people were told, and this, I think 75% is material, Your Honors, that they were, the assets of these funds, 75% of them will be invested in such securities that by themselves are not covered securities. The fact that they invested in some covered securities was not material, and in fact, in the complaint, the allegations of fraud in this complaint, in the direct claims against the fund and the directors, are based solely on this representation. And I invite you to look again at pages 154 to 164 of the appendix, where nowhere is mentioned the fact that these people wanted to buy corporate securities. Yes, the prospectus says that they could buy some preferred stock, but it said that 75% of it would be in corporate bonds of European indices, etc. So I think we need to look at choice and say, like, what is the intent? And the intent comes from the complaint.
So you're saying, you essentially are saying that the covered securities are negligible compared to the expectation that non-covered securities were the primary part of the representations made here.
I think what Justice Breyer is doing in Troyes is that they are aligning this host of, in connection with language that in David said it was broad, and the Six Circuits have different wordings for what the in connection means. And they said, like, look, you have to look at the intent of these people when they bought. This case has not been litigated. So the intent has to be derived from the complaint itself. And the complaint, the only fraud representations they make are in connection with these corporate bond debt securities issued by a Spanish bank that they were supposed to arrange, where they said, they promised in the investment objective that 75% of its assets will be invested in those securities. And I think that's material. I think that these people could have invested in other mutual funds. They could have bought the shares of Popular in their own accounts. It's very easy to do. What they could not find, because they were not a qualified buyer, were those bonds that they wanted to invest through. They wanted to use this fund to get to expose their clients to that markets that are not available in Puerto Rico. Therefore, I think that we need to look at the plain language of Troyes. And a police here, they're inviting this court to interpret Troyes, which was decided 3 months ago, and revive an interpretation of the in connection with language of LUSA adopted by the Second Circuit in cases before, when such interpretation, I think, was squarely rejected by the Supreme Court in Troyes. I think we need to look at the facts. We're talking about uncovered security, and the reason these investors invested were because they were promised this fund would invest in yet another uncovered security, corporate bonds of Spain, European, and global markets. 75%. And I think that was a material decision when they invested.
The representations, what I'm concerned with is whether we have an allocation question. According to what you're saying, the investors were told that 75% were going to be put in these Spanish bonds. The other 25% were going to be put in covered securities?
No, they said debt securities of preferred stocks. They didn't mention the word naturally traded securities.
Yeah,
they didn't mention that in the prospectus.
I know that, but if you read the prospectus, you would expect that at least that 25% would be in covered securities.
Yeah, but I think
all right. So and what your complaint says is that there's fraud because they never followed through on the investment strategy. Strategy is the term.
Objective.
I think the complaint says strategy. All right, described in the prospectus. So what I don't get, if the fraud is that they promised you 75-25, and instead they flipped the proportions. They invested 75 in the covered securities, which turned out to be Lehman bonds that were worthless, all right, and invested much less in the uncovered securities. Isn't the fraud still in connection with covered securities?
No, it is not, because what they promised, we're not talking about a 10B case here, Your Honors. We have Puerto Rico Investment Companies Act of 1954. It's the only Investment Companies Act of a state jurisdiction in the United States. These funds are exempt from registration from the 40 Act. So the pervasive scheme is what the Puerto Rico law says, and that is the Puerto Rico Investment Companies Act. They have to invest.
But wait a minute. But our first concern has got to be less what the Puerto Rico Act says and more what SLUSA says. All right, and SLUSA has been considered by most courts to be coterminous with 10b.
Yeah, I agree. But the thing is that I think my reading of Troy's and Justice Breyer's opinion is that you have to look at what the investors did when they invested in this fund, what it made it different, what they made their decision to invest in this fund. It was not because they wanted to buy popular shares. It was because they wanted to buy 75% of their stock in corporate bonds issued by a Spanish bank. And that didn't happen. And that's a fraud. And the fraud is not that they lost value. The fraud is that they didn't do it because they could not do it. And we haven't litigated that issue, Your Honors. But I think...
But you want us to focus on intent rather than purpose, right?
It's the intent of that's what it says. It's like, that's what the language in Troy says. Your Honors, if this case has great policy issues here, because these funds, there are over $20 billion in Puerto Rico fund money for Puerto Rican investors in these mutual companies. The law says that 67% has to be invested in Puerto Rico securities and 33% in U.S. securities. This fund got an exemption from that requirement of law to invest 75% in these corporate global bonds and the rest according to the law. What I'm telling you is that these shareholders cannot allege fraud against the board of directors or the funds themselves because they cannot avail themselves of the remedies of the 40 Act. And if we go to Puerto Rico and these funds buy one covered security or 10% in covered securities, and we remove this case to federal court to be dismissed because the dismissal is automatic. It could be even sua sponte, some cases have said. These people will not be able to invest in these funds because there is no legal security. They will never be able to carry class action claims against the fraudsters in these funds. And as you know, recently in August of 2013, the Puerto Rico bond market plummeted. And there will be hundreds of lawsuits in Puerto Rico claiming fraudulent representations by these people. And they will be easily removed and dismissed in federal court. So they will not have an avenue to carry out a class action remedy of a court that is purely local. So this is a purely local issue, Your Honor. Thank you.
Thank you.
May it please the Court. My name is Michael Flynn from the law firm of Davis, Polk & Wardwell, here on behalf of Applee PricewaterhouseCoopers. Counsel for Applee, San Juan Management, and I have agreed to split time. I'm going to handle the SLUSA issues, and my colleague will cover the broader waiver issues that stem from the repeated failure of the appellants to challenge below the motions to dismiss. With respect to the application of SLUSA, we submit that the ruling below should be affirmed. Plaintiffs made one and only one argument against the application of SLUSA below, and that was in connection with the motion to remand, and that is that SLUSA could only be applicable if the shares of the fund that they purchased were covered securities. In its dismissal order, the district court made clear that plaintiffs were making that one and only one argument, and importantly, the district court also made clear that the plaintiffs did not contest the basic facts on which our arguments for SLUSA preclusion were based. To quote the district court, plaintiffs do not deny having alleged in their complaint that the defendants misrepresented and omitted material information about the fund's investment objectives, level of diversification, and anticipated investments. The court further noted that these misrepresentations related to various covered securities. Plaintiffs do not contest the court's holding in that regard, nor do they argue that the defendants' alleged misrepresentations did not sufficiently coincide with covered securities, nor do plaintiffs deny that the fund actually purchased and held covered securities, the decline in value of which contributed to their claim for damages. The only argument is that SLUSA does not apply because the fund's common stock is not itself a covered security. That one and only argument was correctly rejected by two separate district judges below. Both before and after the Supreme Court's decision in the Troy's case, it is clear that the purchase of a covered security by the plaintiff is not a prerequisite to the application of SLUSA. Indeed, Troy's confirms that plaintiffs themselves need not purchase covered securities in order for SLUSA to apply. Just last week, as Judge Selya mentioned, the Second Circuit issued an opinion discussing the Supreme Court's opinion in Troy's. The Second Circuit determined that SLUSA applied to claims of investors in a fund which had invested with Madoff, even though the shares of the fund were not themselves covered securities. The situation in Troyes was very different than the situation in Herald and the situation in this case. In Troyes, plaintiffs there purchased fixed-rate CDs. The plaintiff's investment was, in no fashion, an attempt to try to invest directly or indirectly in covered securities. Here, as in Herald, plaintiffs alleged that they were induced to make investment decisions based on misstatements and omissions regarding the investment strategy of the fund. That, as Herald holds, is sufficient to satisfy the in connection with requirement because the diversification strategy included various covered securities. Now, for the first time on appeal, appellants argue that the in connection with requirement is not satisfied because the alleged misstatements and omissions underlying the action do not sufficiently coincide with the purchase or sale of covered securities.
Go ahead. No.
So if the prospectus indicated that 1% would be covered in covered funds and 99% in the European market, you would say that's enough?
Well, I think there's a misapplication of the materiality standard in this context by counsel for appellants. The test under SLUSA, and as Troyes makes clear, is that the decision to invest had to be material to the purchase or sale of a covered security. It doesn't say that you have to look at how many covered securities versus how many non-covered securities. As long as there is a fraud or misrepresentation or omission in connection that's material to the purchase or sale of a covered security, SLUSA is satisfied.
But they're saying the fraud was in connection with the purchase of a non-covered security. That's their argument. They're saying they don't care about the 25%. It's the fact that they were promised something materially different, which is not a covered security, and didn't get it. They're saying that's the fraud.
Well, what they're saying, Your Honor, is clear from their briefs at page 15 and 29, that they themselves characterize their action as, one, making anti-fraud claims having to do with misleading statements regarding the fund's investment objectives and fundamental investment strategy and policies. Those allegedly fraudulent investment objectives and policies provided that the fund would pursue a diversification strategy that included investments in several categories of covered securities, including preferred stock, securities of 40 Act companies, exchange-traded options and futures, repurchase agreements related to covered securities. If you look at pages 186, 199, 201, 202, and 204 of the appendix, that is clear. There's no dispute that that is what the prospectus said. In fact, the district court, in denying the motion to remand, observed that a plain reading of the fund's prospectus reveals that the fund's anticipated investments included various covered securities. That's at page 4 of the remand denial order. Rather than pursue the articulated investment strategy set forth in the prospectus, plaintiffs allege that defendants failed to disclose that the fund's managers fraudulently pursued a different strategy, one that caused the fund to abandon the articulated diversification strategy involving covered securities by investing in toxic Lehman assets and not investing in the notes that counsel for appellant mentioned earlier. That is directly contrary to the diversification strategy involving covered securities that's laid out in the prospectus. Just as in the Herald case recently decided by the Second Circuit, plaintiffs here allege that they were fraudulently induced to invest in shares of a fund by misrepresentations and omissions about the fund's investment strategy to purchase, among other things, covered securities. Applying SUSA to such a situation as the Second Circuit just decided last week is fully consistent with Troyes. It's also fully consistent with the 11th Circuit case of Instituto versus Merrill Lynch, in which securities were not purchased, even though the defendant in that case was alleged to have represented that they would purchase covered securities, and in that case they were not purchased, and the 11th Circuit determined that because the covered securities were marketed to the plaintiffs, the in connection with requirement was satisfied. We think, Your Honors, that in this particular case, given the arguments made below, given the language of Troyes and the recent decision of the Second Circuit, as well as other decisions such as Dabbitt and the Instituto case, and by the way, the Supreme Court in the Troyes case made clear that Dabbitt was not modified, and it's clear, I think, based on the nature of the allegations and the findings of the district court below, construing those allegations, that the in connection with requirement here is satisfied, and we believe on that basis the the decision below should be affirmed. If the court has no other questions, I'll yield the balance of my time to my colleague.
May it please the court, Eric Perez Ochoa on behalf of Appalese, San Juan Asset Management, and Jose Vizcarrondo. I will focus my argument on one significant aspect of this case. That is, plaintiff's failure to oppose any of the motions to dismiss that led to the dismissal in this particular case.
Isn't there argument that it would be futile under SLUSA, and that in fact it's because their ultimate issue was the remand? It didn't belong in federal court in the first place, not the substantive challenge to SLUSA?
Well, Judge, Your Honor, the fact is that that record of inattention, regardless of their argument, cannot be ignored.
Well, no, it's not inattention. Because I share Judge McConnell's view. Their position all along has been that this case ought to be remanded to state court. They have a Rule 11 obligation not to make insupportable allegations to the district court. So they haven't said that if they're wrong on jurisdiction, that the case shouldn't be dismissed. They've conceded that. But what they've consistently maintained is that this case ought to be remanded. So it troubles me that you seem to fault them. You would have wanted them to file an objection, which they could not in good faith have filed.
Your Honor, the position of Appalese San Juan Asset Management and Vizcarrondo is that, yes, there were motions to dismiss that were filed. That's undisputed. They had an opportunity to file oppositions. They did not.
What oppositions could they file? Their position is this case doesn't belong here.
They could have filed.
They've made that very clear by their motion to remand and their request to certify that question.
That is true, Your Honor.
And you weren't at any point prejudiced or disadvantaged because you didn't know or understand their position. Judge Cerezo wasn't disadvantaged. Judge McAuliffe wasn't disadvantaged. And so now it seems to me, with all due respect, that you're trying to pounce on a technicality and take advantage of the fact that they acted in a very lawyerly manner in not burdening the court with insupportable allegations.
Well, Judge, that may well be the case, and I need to concede that that could be true. However, that does still have an effect, in our view, in the standard of review to be applied to this case. Because if the arguments were not waived, as the court seems to suggest, of course, then at the very least they were forfeited.
There were no arguments either waived or forfeited with respect to the motion to remand. That's what this appeal is about.
But, Your Honor, they're not appealing from the motion to remand.
No,
they're appealing from the judgment of dismissal that was entered on March 15, 2013.
They're appealing from the judgment, but that appeal brings up with it all of the intermediate orders, and the only order that they're objecting to in substance is the motion to remand, because if that motion was improperly denied, the dismissal motion becomes moot. You know it, I know it, the district judges knew it.
We continue to maintain, Your Honor, and we understand the court's position, that there is a waiver forfeiture, at the very least forfeiture argument here, that needs to be taken into consideration. Because, of the fact that they did not oppose the motions to dismiss, they did not file any responses to the several motions by the defendant seeking that motion to dismiss to be deemed unopposed. They did not file any post-judgment motions seeking relief under 59E or 60B, challenging the dismissal. And quite frankly, that this is a case that's very similar to Pomerleau and to the case of Torres Fuentes, where this court pretty much determined that on the basis of a motion to dismiss under 12B6 that goes unopposed, there's a waiver rule of Local Rule 7B of the Local Rules of Puerto Rico. There's a raise or waive rule that may apply, and the principle that a party who fails to object to a motion to dismiss must raise a claim of error by filing the appropriate post-judgment motion or forfeit the right to raise his claims before this court as decided in Rocafort versus IBM. And that, simply the position is that, this court should not put flesh in plaintiff's bone, even if that might seem a bit unsympathetic. And that would be the position of Appalese San Juan Asset Management and Vizcarrondo. Thank you.
All right. Oh, he's got 3 minutes.
Your Honors, nothing further. Thank you for your time.
Can I just ask you one question to follow up on something Judge Thompson asked? If the prospectus had said 10% would be invested in, for lack of, I wouldn't say this, but in non-covered securities, if 10%, would your argument be the same, or does your argument rest on the fact that such a substantial amount was non-covered claims to defeat the in-connection portion?
My argument doesn't have to do with the 75%. The argument has to do with the fact that what is this product? What is this fund about, and why people invested in these funds? For instance, if you have a local Puerto Rico investment company, and the reason people do this in Puerto Rico because it has tax advantages to Puerto Ricans, okay? If you have a Puerto Rico investment companies that said in its investment objective, we're going to track the S&P 500 index, all of them cover securities, SLUSA would apply. What I'm saying here is that the fund itself is not a covered security, and Justice Breyer is very clear that we're talking here about uncovered securities, and the court should not worry too much about uncovered securities. But the fact is that whatever says the diversification statute, they said 75% of the assets will be invested in the global corporate bond market. And that didn't happen, and that's the only complaint that we're raising in the complaints and the pages that I just quoted. So I think that's what makes the difference in this case.
What do you say to your brother's argument that the only argument that you made in the district court was that SLUSA didn't apply because the shares of San Juan Asset Management itself weren't publicly traded?
Well, we filed a motion for remand, and the case says that if only one element of these 4 elements of SLUSA doesn't apply, then it doesn't apply. We said we don't have a covered security. We never thought that we had to raise the in connection with language because of the 75%. And to be honest, this case was filed in local court because we didn't avail ourselves of any remedies under the 40 Act.
But on the motion for remand, you only apparently argued this one theory, all right? And then when that motion to remand got denied, you then moved for 28 U.S.C. 1292B certification, all right? And you again in that certification asked only to have this one question certified. Why isn't that a waiver of other SLUSA-related questions that weren't waived below?
In the 1292B motion, I think we mentioned the in connection with requirement. We were answering Judge McAuliffe's and Judge Cerezo's legal reasoning, and we were trying to appeal from that reasoning. I don't think we waived that argument, Your Honors, but let me point out briefly before I finish. The case that we cited, Kircher versus Putnam Funds, at page 64, Justice Souter said, and the time is up, a motion to remand claiming the action is not precluded must be seen as posing a jurisdictional issue. We've always said that this is a jurisdictional issue, even though I'm participating in this appeal only. But whatever it says down and the motion's down, if you raise a motion to remand saying that SLUSA doesn't apply, you don't waive the issues. The issues are always present. And we urge you, Your Honors, to consider this case and the policy implications of this case for these plaintiffs and potential plaintiffs in Puerto Rico. Thank you.